All right, this time you will hear closing arguments from defense counsel, Mr. Matthews, and I will tell you that each attorney has told me that they will take about an hour in presenting their closing argument to you. We will take a break between the two closing arguments. Mr. Matthews?
Thank you, Your Honor. May it please the court, Ms. Will, Mr. Finke. Ladies and gentlemen, good morning. Hopefully I will not take an hour, but I don't know. I haven't timed it. Ladies and gentlemen, I'd like to start out by thanking each and every one of you for agreeing to participate in this trial. We've been here, it seems like, for long days, for a lot of days. We're now at the end. But I know you've paid close and careful attention. I've seen all of you during the course of this trial taking notes and paying attention. That's all we ask you to do. I'm not going to delve into all the facts. You've heard facts over and over again, and I don't think there's a whole lot of dispute between the Commonwealth and between us over most of the facts. Some of the facts are disputed, but most of the facts are not. The big dispute in this case is how do you interpret those facts? And before I get into a lot of things, I would like to, there are a few issues I'd like to discuss preliminarily. First and foremost, I think everybody in this courtroom and probably everybody in this world agrees that the death of Breonna Taylor was a terrible thing. As Brett Hankison said yesterday, it should not have occurred. I think we can all agree on that, but I think we all know that this case is not about the death of Breonna Taylor. It's about Cody Etherton, Chelsea Napper, and their son Jaden. And what happened to them is a terrible thing also. But fortunately, none of them were physically injured. You saw particularly Chelsea the other day talk about the trauma and the emotional upset that it caused she and her family. And there's no disputing that. You'll have Defendant's Exhibit Number 1, and I apologize for sounding a bit callous here, but you'll have Defendant's Exhibit Number 1 in the jury room with you, which is a copy of a civil lawsuit that they filed against Louisville Metro government, the Louisville Metro Police Department, Detective Brett Hankison, and 8 or 9 other police officers, which seeks as compensation for what they've been through in 3 different counts, $12 million and $1, 3 times over. So for a total of $36 million and $3 is what they're seeking for compensation. And while I suspect they're not going to get that kind of compensation, I believe they probably will get compensated as a result of this. That's not going to undo what happened on March the 13th, but I think it would go a long way toward alleviating some of the emotional distress that they've been put through. Ladies and gentlemen, there's a common denominator to this case, and that person is not on trial here. That's Kenneth Walker. He's the fellow who fired the bullet, the initial bullet that struck Sergeant Jon Mattingly while he was in the performance of his duties as a police officer, serving the search warrant at 3003 Springfield Drive. The search warrant itself was something that the officers all had a right to be where they were. They were doing what they were instructed to do. The problem is, with that search warrant, is that the officers were ill-prepared to go out to 3003 Springfield Drive, as it turns out. You know, we've heard testimony about no-knock search warrants, and you have heard those described to you as what that is. We've heard that this was served as a knock-and-announce warrant. The no-knock warrant is how it was issued. That is, the police have the right to go out to 3003 Springfield Drive to Breonna Taylor's apartment and just break in that door and search for the documents and whatever else, whatever other contraband they may have been looking for or could find. Somewhere along the line, they were told not to do that. Go out and knock and announce and let the folks know we're here. And the reason that was done is, number one, the information provided to the officers who went to 3003 Springfield at the briefing at the CID office on Ormsby before everybody went out on these different search warrants was that at 3003 Springfield Apartment 4 there was a single female living there who had no children, no pets. There was nothing there to indicate that there would be any problems with the execution of the search warrant, no issues. So it was considered a low-risk entry that they were going to make. So be courteous, knock and announce, and let somebody know we're here and give them a chance to answer the door. Well, what happens? The police show up, they knock and announce, and there's been a lot of controversy about whether knocking and announcing occurred. Every officer who testified here said that we knocked for a prolonged period of time. We announced ourselves as police officers, and the issue is, are the officers telling the truth? Well, we heard from Aaron Sarpay, the neighbor from upstairs in apartment 8, not the neighbor, he was in apartment 8 upstairs picking up his daughter from the babysitter. He came in, and in the courtroom here, he denied hearing that the police announced themselves or identified themselves as police officers. But you heard a taped statement that he gave to Detective Herman Hall with the Kentucky Attorney General's office early in the investigation, admitting, or not admitting, but stating that he heard the police announce themselves and identify themselves as police. He's backed off of that at this point for some reason, but he heard it. He's an independent witness who verified that the police did identify themselves. So that's the irony of that situation is that had the police gone out there and done a no-knock warrant and just broke in the apartment, nobody would have had an opportunity to get a gun and shoot Sergeant Jon Mattingly. They would have been taken, in all likelihood, taken by surprise, and this incident never would have occurred. Aaron Sarpay, remember his testimony. He number one, he said police identified themselves as police. He also said that when the entry was made, he was back in the apartment 8, because he and Brett Hankison had had a little disagreement about him being outside and him wanting to come out. Brett sent him back in the apartment. He went back in, but he said when they broke into that apartment, it sounded like a machine gun going off. He's an Iraqi war veteran, and he knows what the sound of a machine gun is. He said it sounded like a machine gun going off. And that kind of sets the tone for what Brett Hankison was appreciating at the same time and why Brett did what he did. Aaron Sarpay recovered, as you'll recall, and I don't know if this is has any bearing on this case, but I thought it was somewhat important to discuss, and that is the .223 spent casing that Aaron Sarpay found in the gravel that was between the sidewalk and the patios of these apartments at 3003 Springfield. We heard testimony that an AR-15, that's the type of ammunition that gun uses, that rifle uses. You heard Brett Hankison testify that when he saw the muzzle flash as Kenneth Walker discharged his weapon, or whoever shot the Luger, the 9mm gun that struck Jon Mattingly, you heard Brett say he thought that he saw in the muzzle flash an AR-15 rifle, person in a rifle stance. Well, Aaron Sarpay recovers a .223 spent casing outside. So what? Not a big deal. Curious, but probably doesn't mean anything. But then later on, we get another report that there's a .223 spent shell casing found in the bedroom in apartment 4 that was apparently missed by the crime scene unit when they methodically and completely searched apartment 4. They didn't find it, but at some point that casing was turned over to the FBI. It was found in the bedroom where the gun that was used to shoot Sergeant Mattingly happened to be found, and where the window was located that Brett Hankison fired 5 rounds through on this night. Now, again, does that mean anything? Is it a coincidence? Well, we heard Bryce Ziegler, the FBI criminalist fellow who did the firearms examination. He said the spent casing found by Aaron Sarpay and the spent casing found in the bedroom in apartment 4 were fired by the same weapon. Now, I don't know if that means anything or not. He didn't have a weapon. There was no weapon found when CSU did their complete and methodical search. But we also know that the family of Breonna Taylor was granted access to that apartment later in the day on March 13th, the same day this incident occurred. Does that mean anything? I don't know. Is it all coincidental? Perhaps, but I have a problem with coincidences sometimes. It just is a bit curious. Another issue that I find a bit curious in this case is that we know that there were 2 occupied apartments that were struck by gunfire, that of Cody Etherton and Chelsea Napper and their son Jaden. We also know that bullets traveled into apartment 8 upstairs where Aaron Sarpe was picking up his child from the babysitter. It's interesting to me, and we know from Michael Van Arsdale, the FBI trajectory expert, we know from him that the bullets that went into apartment 8 did not originate from Brett Hankison just by way of the trajectories. We know they originated from somebody firing at the front door, either Myles Cosgrove or Jon Mattingly. It's interesting that the only person charged with wanton endangerment for the same conduct is Brett Hankison. Why the Commonwealth chose to charge Brett Hankison with wanton endangerment is a question I've asked myself since the day that an indictment was announced, but nobody else got charged, which was the proper decision, was not to charge anybody, period. I believe, ladies and gentlemen, that Ms. Whaley or Mr. Finke in their closing argument are going to come up and talk about the rules of shooting and how Brett Hankison violated all of those rules. You know, you've heard them over and over again. You have to have a target in sight. You have to know what's in front of, behind, or beside that target. And Brett Hankison didn't do that, is the allegation. You've heard the testimony from Brett. He testified that he saw muzzle flashes at the front door of that apartment. First of all, the apartment was breached, and you have to keep in mind that this entire shooting part of this, from the breach of the door to the end of the shooting, has been described as anywhere from 5 to 15 seconds, I believe. That is fast. The criticism of Brett is that once Jon Mattingly, his friend, was shot and said, "I'm down," Brett moved away from the fatal funnel that's been described and around the side to the patio to the railing where he had a view of the sliding glass door, and he saw the muzzle flashes inside of the apartment. Now, there's been testimony, I think Jason Vance described the curtains that covered the blinds that were over the bedroom windows and the sliding glass door as blackout curtains. Well, a blackout curtain implies to me that you can't see anything through it. And Brett Hankison said that he saw muzzle flashes. Now, people say, well, he couldn't have seen those muzzle flashes. Well, nobody can say what Brett Hankison saw or didn't see. Only Brett Hankison can tell you that. But you'll have with you in the jury room Defendant's Exhibit 5. And this is a picture of curtains. These are the curtains that were on the bedroom window. And you'll be able to look at that, and you can see through those. And I would suggest that blackout curtain was not an appropriate description. There were curtains, there's no question about that. But Brett said he could see muzzle flashes through it, and I think this shows that you can at least see them through the bedroom curtains. I mean, this is a good picture to show you can see through the bedroom curtains. And additionally, so the curtains, I think, are one thing. There's also, you'll have photographs that the Commonwealth introduced that show a mirror on the wall in the living room. What do mirrors do? They reflect things, and I would submit to you that potentially that mirror was reflecting muzzle flashes. So I think that the claim that Brett did not see the muzzle flashes is one that is not proven beyond a reasonable doubt by any means. The next thing is that what he said he did is in response to seeing those muzzle flashes, he perceived that his brother officers were being executed in a fatal funnel at the front door. And when he slid around the side to that where that patio is and fired through the sliding glass door, he was firing at those muzzle flashes. That's not a a target that is a human. You're not looking at a human being such as I'm looking at you and firing, but he is firing at muzzle flashes, which obviously had to originate from a human being. And he kept his firing inside of the apartment door. He wasn't firing at the officers who were out in the vestibule, because he didn't know they were there. He didn't know that, or he knew they were not inside the apartment. He thought the shooter was still inside the apartment. And when the firing continued, he moved down to the bedroom window and fired through that at the location where he had initially seen the shooter who shot Jon Mattingly. And you're going to have Michael Van Arsdale's trajectory report back there with you in the jury room when you deliberate. And you can see, and you saw it in here, but you can review it. And the shot pattern is exactly where Brett Hankison intended those to go. Unfortunately, 3 of the shots at the muzzle flashes at the front door went astray into the apartment next door, which we know that Brett Hankison and any of the other officers who were sent out to serve that warrant had no idea existed. It's not obvious when you walk up to the place that there's an apartment right behind Breonna Taylor's apartment, and you heard Myles Cosgrove in his video deposition say an operations plan generally would include information about the layout of the place we're going to, perhaps photographs. None of that occurred. They did not have a diagram. Nobody had any knowledge other than we're going to apartment 4. And I would submit to you that Brett Hankison did not know there was an apartment behind Breonna Taylor's that his bullets could go into, and I would submit that even if he had, he did what he thought he had to do in that instant. And that's what you have to be cognizant of, is this all happened in such a short span. He's a police officer. You know, it makes me think sometimes of when the plane struck the Twin Towers on September 11th. There were pictures of people running away from the smoke and the debris and everything that was coming down. And in those same pictures, there were pictures of police officers and firefighters running toward that danger. That's what emergency personnel are taught to do. They run toward the danger, and that's what Brett Hankison did here. He could have, when he swung out, and there's been some suggestion that perhaps he abandoned his brother officers when he swung away and went around the corner. He could have run straight out to that parking lot and just kept going, but he did not. He ran around the corner and took efforts to save what he thought he was doing was saving his brother officers as they were being shot in that fatal funnel. Ladies and gentlemen, the bottom line is that through all this, the Commonwealth is trying to say that because Brett Hankison took the actions he took, he's a criminal and he deserves to be in prison. I submit that Brett Hankison's the farthest thing from that. You heard how he reacted to try to save his brother officers. You heard everything he did, police-related activities that he engaged in after the shooting was over, including calling the EMS, notifying officers to come for backup, having an officer ram the gate, setting up a perimeter around the building. He's criticized because he didn't go right to PIU. There's nobody that says that that's a mandatory requirement. Chief Conrad said that's protocol, but it's not any kind of mandatory requirement. Brett went there to check on his friend and his brother officer, Jon Mattingly. He didn't do anything wrong by going to the hospital before he went down to the PIU unit, where he went after he left the hospital, and where several days later he came and provided a voluntary statement as he was requested to do, and as you saw on the screen here. So he's cooperated ever since. He doesn't believe he did anything wrong. Now, having said all that, ladies and gentlemen, the issue is, did Brett do something that was an unreasonable choice in the split second that he had to make a decision of whether he should do anything or do nothing? He chose in that split second to go do what he perceived needed to be done, and that was to save his brother officers. So he simply reacted as I would believe that most police officers would react when danger presented itself. Bottom line is, ladies and gentlemen, you have to be convinced of the truth of the charges here. 3 counts of wanton endangerment beyond a reasonable doubt. And beyond a reasonable doubt is not defined in Kentucky. It's simply it'll be the final 12 of you who are sitting on the jury. It's your collective agreement on what reasonable doubt is. And I would suggest to you that this case is full of reasonable doubt as to whether Brett Hankison committed the offenses of wanton endangerment. Now, the most important part of this whole thing is the instructions the judge just read to you. She read you the instruction of what the statute of wanton endangerment says. And if you read that, it makes some sense, but you can't understand it if you don't understand the definition of wantonly. So on page 3 of those instructions, the term wantonly is defined, just as the Kentucky legislature ordered it to be defined. And if you go through that definition, ladies and gentlemen, I think if you read it all at once, it's a little bit difficult to understand, but if you break it down into sections and segments, you have to look at a person acts wantonly with respect to a result or to a circumstance described by statute defining an offense when he is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that circumstances exist. The testimony in the case, ladies and gentlemen, again, is that Brett Hankison did not know that there was an apartment behind Breonna Taylor's apartment, apartment 4. He didn't know of the existence of apartment 3. And I would suggest to you that in order for him to have consciously disregarded a substantial and unjustifiable risk, he would have to be aware of the existence of that apartment. It doesn't say be aware of or should be aware of, it says be aware of. That means he had to know that that apartment was back there, and then he had to consciously disregard the substantial and unjustifiable risk. Well, there's two things there to consider. Number one, if you don't know it exists, how can you consciously or otherwise disregard it? And then number two is, was it unjustifiable? You all have to determine, was it the risk, even if he knew it, was it unjustifiable for him to fire in what he thought was the defense of his brother officers who he thought were being or perceived as being executed in the fatal funnel? As it turns out, they were not. His perception was wrong, but remember, he had to make that split-second decision in that very short period. The next sentence of that wantonly definition says the risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in this situation. Well, was Brett Hankison's returning fire on what he perceived as someone executing his brother officers a gross deviation from the standard of conduct that a reasonable person would exercise? I would submit to you that a reasonable person would do exactly what Brett Hankison did if he sees his one brother officer being shot and perceives that his other brother officers are in the line of fire and being executed. He did what he had to do that day. The fact that his bullets traveled through apartment 4, through the drywall, common wall to apartment 3 is a terrible thing. But it's not criminal, ladies and gentlemen. It's kind of like what you might call it collateral damage. Fortunately, nobody was hurt in apartment 3, just as nobody was hurt up in apartment 8 with the bullets that went up there. But I would submit to you, ladies and gentlemen, if after you consider all this evidence, you have to come to one conclusion, and that is Brett Hankison was doing his duty that night, doing his job. Things went terribly wrong, but his actions were not criminal, and he does not deserve to be sent to prison for what happened on March the 13th, 2020. Thank you, and I would ask you, ladies and gentlemen, please bring back 3 signed not guilty verdicts. Thank you.
All right, ladies and gentlemen, as I told you, we'll take a brief break, so let's break for 10 minutes, and we'll resume the trial at 25 till 11. And please don't discuss the case with each other. Thank you.
All rise for the recording jury.